and you didn't report on the 19th, you didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up. And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't, Monday, you weren't working and you still didn't go until late, actually after the agent that's assigned to your case at Community Corrections had left.
Hello guys, and welcome back to the channel. Today we are going to see a court case entitled Brat Sent to Jail for Ignoring Judge's Orders Before Sentencing, so let's watch it together.
They were sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. But I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to Community Corrections, but because she had her child with her, Community Corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the Community Corrections is closed on the weekend, she wasn't able to do that. She is working full-time, works at EHM Senior Solutions in Saline. She's been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
Problem that I have, Ms. Wilson, is that on the 17th you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty blow, I had told you to report to Community Corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Can I talk?
Yeah.
I worked both.
What'd you say?
I worked Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad, or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
The child so there was time for work excuses and last-minute babysitting, but not for following a clear court order. How convenient waiting until 3:50 p.m. On Monday, just a total accident, right? Sorry, but this court isn't here to play babysitter. Actions have consequences, not.
Well, I'll watch it.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober line, right? The alleged blood alcohol content was 0.085. There was an accident. During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober leg either.
Yeah, because the device locked. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link. On the 18th, it gave her an error that it had to be reset.
And you did nothing.
Bring my kid in there, I can't.
But you did nothing. And then let me ask you this. Do you not take this seriously at all?
I do take it serious. Yeah, I'm busy. I'm a very busy person.
Okay.
And that's not an excuse,
We all are.
but it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient. It's all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
Right.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever
So it's all just so inconvenient. Must be tough balancing responsibilities when one of them includes not drinking and crashing a car. But hey, excuses are fun. Too busy, too young, too confused, too everything except accountable. And the best part, the court is supposed to just nod along and be impressed. Sorry, but the only thing actually inconvenient here is having to explain basic consequence to an adult who still thinks responsibility is optional.
But Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Well, let's say 20 violations of basically, well, actually, it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one, she drank. Then, even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test on 2 occasions for her testing that day between 7 and 10 a.m. and 2 to 5 p.m. She didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month. And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now, and set this out to the 24th, and now I get here and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just,
Yeah.
I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor. If she's able to continue on to bench.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out in bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You missed going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it. In fact, so that we're also clear on the 19th, on the 18th, community corrections talked to you that day. Mm-hmm. And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
Oh, so now it's a thought that counts situation. I thought I could, but I couldn't. That's not how court orders work. This isn't some casual RSVP where you just show up when it fits your schedule, and let's not pretend like this is a one-time oopsie. There's a whole novel of missed tests, skipped check-ins, and broken promises, but sure, keep the excuses coming. Maybe next time just say I was gonna, but then I decided not to. At least that would be honest.
That's a Friday. And you didn't report on the 19th. You didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up. And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't, Monday, you weren't working. And you still didn't go until late, actually, after the agent that's assigned to your case at Community Corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether. Because otherwise, you'd be showing up today with no tether. And mind you, that the person that did that did it after the agent that's assigned to your case had terminated you from community correction supervision because you weren't compliant. Anything else?
And further, nothing further, Your Honor.
Lady, you're going to have to learn to just pay attention. When court tells you to do something, you're going to have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. So, sentence of the court, defendant remanded to the Washtenaw County Jail to serve 5 days for the violation.